All right. Good. Good evening to all of you. The other species of bailment is the law of pledge. Pledge, or it is also called pawn. It is contained from section 172 to 179. Before we go into the subject, we must know the definition of the word pledge or pawn. Where movable property, where possession of movable property is given as is furnished as security for the fulfillment of a loan or performance of an obligation, it is called a pledge or it is called a pawn. The person who offers the movable property as security is called the pawnor or the pledger, and the person to whom the movable property is offered as security is called the pawnee or is called the pledgee. And the transaction is called a law of pledge or it is also called a pawn. You had a similar provision in the Transfer of Property Act, where we studied what is called the law of that is law of mortgages. In law of mortgages, how in section 58 of the Transfer of Property Act, mortgage has been defined as where an interest in respect of, please remember, where an interest in respect of specific immovable property is created for the purpose of securing a loan paid, promised, part paid, or part promised. The transaction is called a mortgage, and the person who offers a security is called the mortgagor, and the person to whom the property is offered as security is called the mortgagee, and the transaction is called a mortgage, and it involves immovable property, and the interest that is created is as a security to secure the loan. In the same way, as far as the law of pledge is concerned, movable property is offered as security for the purpose of securing a loan or performance of contractual duty. It is called a law. It is called pledge or it is called pawn. The person who deposits the movable property as a security is called the pawnor, and the person to whom the movable property is offered as security is called the pawnee, and the transaction is called a pledge or it is called a pawn. Here, how many parties are there in a law of pledge? There are two parties, one called the pledger and another called the pledgee, or one called the pawnor and another called the pawnee. And what is involved, sir? There must be a monetary liability or there must be a pecuniary liability, and the movable property that has been offered as security is for the purpose of satisfying the loan or for performance of a contractual duty. So here what is delivered by the pawnor to the pawnee is possession of movable property. For what purpose? For honoring a pecuniary liability, that is a money liability, and also of a performance of a contractual obligation, and also with a specific understanding that the debt has to be cleared within a specified time. And there is a charge created over the movable property which is offered as security for the till the payment of the debt is completely made. And here, the person who offers the immovable property as security is called the pawnor or is called the pledger, and the person to whom the movable property is offered as security is called the pawnee or is called the pledgee. So, a pledge can be created only in respect of movable property, and a mortgage can be created only in respect of immovable property. Second condition is a pledge or a mortgage, there should be a monetary liability, and it can be only for honoring a monetary liability. The movable or immovable property is offered as security. Though the pawnor or though the pledger comes into possession of movable property, please remember one thing: he does not become the owner of the movable property. The ownership remains with the pawnee or with the pledgee. For what purpose, sir? To see that the loan is paid within time, and also if there is any contractual obligation, the obligation is performed in the letter as well as in the spirit. Then, sir, we also defined yesterday the hypothecation. If you look into the word hypothecation, hypothecation is not defined anywhere. Even if you go through your law lexicon or the Oxford Dictionary or the Webster Dictionary, you cannot get the meaning of the word hypothecation. Hypothecation is loosely defined as pledge of immobile property. Why? How do you say, sir, pledge can arise only in respect of mobile property? How do you say it's pledge of immobile property? Suppose, let us say, you apply for a loan for business purposes and you want to install a printing machinery. Printing machinery is normally a mobile property, but once it is embedded, once it is attached, fixed to the earth with nuts and bolts, it acquires the characteristics of an immobile property. That is the reason it is called a hypothecation. And the person who creates the hypothecation is called is called the pledger or is called the mortgager, and the person in whose favor the property is offered as security is called the hypothecatee, and the transaction is called hypothecation. Then you take the case of a loan which is advance for a vehicle. For example, you apply for a car loan. The first and foremost is that the car loan will not be granted to you unless you offer the car, hypothecate the car or offer it as a security for performance of your pecuniary liability or for honoring the debt. Then the question is, it is also called hypothecation because car by itself is a mobile, that is the raw materials which are used as far as the car is concerned, it is supposed to be mobile property. But once the entire body is fixed, body building is done, it acquires the characteristics of immobile property. That is the reason it is called hypothecation. Then, sir, the here it is said bailment of a chattel. That is normally this pledge arises or pawn arises when you are in distress. You require money for your personal expenses, or you require money for your business purpose, or you require money for performing your daughter's marriage or your sister's marriage. Then your wife has got. Please remember, it's a very very peculiar problem. A lady will part with anything except the jewels which are given to her as santhanam. But the question is, jewels are readily available to you to raise a loan. Then it is better you go to a bank. Then in the bank you have the valuer or you got the appraiser who weighs the jewels, then takes out the copper content, the labor charges, as well as the gilt stones, if any, and then comes to a conclusion that this is a net weight. Per gram, a rate will be fixed, and accordingly, the money will be paid, and the goods which are offered as security will be inventory, and a list will be kept and maintained by the bank on the condition, and the loan is granted on the strength of the security furnished to the jewels on the condition that the pawnee that the pawnor has to pay the installments regularly with interest, and then after the within that period which is granted to him, 2 years or 3 years as the case may be, and the interest part of it is as paid, and once the period of the loan comes to an end, the entire amount, whatever is due under the transaction, has to be paid in full to the pawnee. And please remember, pawnee comes into possession of only the goods or the gold ornaments, but he does not become the owner as far as the goods are, as far as the gold is concerned, because what is given is only a security and not an outright sale. That is, in other words, pawnee comes into possession, but the ownership remains with the pawnor, or the ownership remains with the pledger. And what is offered is that what is why it is offered is to honor a pecuniary liability or to see that the debt which is taken from the bank is paid, and on payment of the money, the pawnor is entitled to get back the jewels duly redeemed. That is according to the list. And then you will also be given a certificate that the loan is completely cleared and the bank has no claim as against you. So here a bailment which conveys the property owned by a debtor to a creditor to secure repayment for the same debt or obligation and to the mutual benefit of both. Here, what is the mutual benefit which accrues, sir? The mutual benefit which accrues is the pawnee becomes entitled to keep the jewels as a security, and then once the pawnee parts with the money by way of a loan, the pawnee gets benefited. But the pawnee also gets benefited because he gets into possession of the movable property or the jewels which is offered as security. And please remember, it's always a deterrent that you must clear the loan, pay the interest, pay the incidental charges, pay the EMIs from time to time. Unless you pay them, you are not entitled to get back the jewels. So it's a mutual benefit to both of them. That is a pawnee as well as a pawnee. The question is, pawnee gets the money. Pawnee gets the money, and the pawnee parts with money and keeps the security of the jewels and for the due repayment of the debt. Then, sir, we go to, as per section 172, pledge is a contract where a party deposits and deposits goods both the with the lender for security for the repay. Again, I'm repeating it, sir. It is only as a security, and the pawnee comes into possession of the goods, but he is not the owner. But the ownership remains with the pawnee. And here, what are the features, sir? Properties under pledge to be delivered. First and foremost is, you can say so many things. It's a security, but the possession of the goods has to be delivered by the pawnee to the pawnee. The second one is Dharma. Second one is that pursuance of a contract. What is the contract between the pawnee and the pawnee, sir? That there is a loan liability. There is a pecuniary liability. Money is lent by the pawnee to the pawnee. Then, as security subject to return. Please remember, the pawnee, though the pawnee comes into possession of the goods, he is not the owner. He is only a possessor. He is only a manager. He is only a trustee. He is only an administrator. But as soon as the loan is cleared, he has to return the goods to the pawnee. And this right is called the right of redemption. Then rights of the pawnee is, pawnee has a right to retain the goods pledged until payment of the debt, interest and any other expense incurred for maintenance of such goods. Example, X pledges his gold ornament jewelry for some loan from a bank. In such a case, the bank has a right to retain the goods for till such payment. First one is the banker who advances the loan, or called the gold loan, and takes the gold jewels as a security, has got a right of lien. He can detain the goods, he can retain the goods, he can remain in possession of the goods till such time the entire debt is cleared. So, in other words, the pawnee is the possessor of the goods, but the title of the goods remains with the pawnee. Then, second one is, pawnee can file a suit for recovery of loan while retaining the goods. He can not only exercise the right of lien, he can not only exercise the possession, but also he can bring a suit to recover the money, whatever is due and payable by the pawnee or the pledger towards the loan. Third one is, pawnee can seek reimbursement of extraordinary expenses, but cannot retain the goods. Sometimes what happens is, the banker has no sufficient space. He hires a place for the purpose of keeping the security, and let us say for that he has to pay the rentals and any expenses that are required, that are incurred for the purpose of keeping possession of the goods pledged. Then in that case, that money which he has spent, he has got a right of recovery as against the pawnee, but under the condition that whatever is pawned, he must return it back to the pawnee. Then next one is right to sale and sue for deficiency. In case the payment is not made, in case, let us say, the interest is not paid, expenses are not paid, then the due period also is over or coming to an end. The pledger, the pledgee or the pawnee can sue the pledger or the pawnee for the money whatever is due, and also recover the expenses which is incurred in keeping the pledged property. Then, sir, right of the pawnee is In case pawnee makes any unauthorized sale of goods without the notice of the following rights are available: suit for redemption by paying the debt, damages for conversion. Please remember, conversion is a peculiar remedy. Conversion means, what do you mean? The question is, when you usurp someone's property and use it for your own benefit and to the detriment of the other, you are only a possessor of the goods. You are not the owner of the goods, but you convert the goods as if it is your own goods and make a profit over it, and you make unauthorized use of the pledged goods, and then you do not take the consent of the pledgee or the consent of the pledger or consent of the pawnor and say and use make unauthorized use of that. Then in that case, the pawnor is entitled not only for redemption on payment of the debt, but also for damages for converting the goods into the own use of the pawnee. Then second one is damages. Then what do you understand by pledge of by a non-owner? Usually, owner pledges the goods, but under circumstances, the law permits a non-owner who is in possession to pledge. Thus, the following one non-owner who may create a pledge: mercantile agent who is in possession of goods. Sometimes, please remember, under the law of privity of contract, only the contract binds the previous to the contract. A stranger to a contract cannot sue on the contract or cannot take the benefit of a contract. But in the certain circumstances, with the permission or with the consent of the true owner, the mercantile agent, that's a person who is a commercial agent, undertakes business carrying goods of one person to one place to another. Then he says mercantile agent who is in possession of the goods. That is, goods are in transit or the goods are handed over to a mercantile agent. Mercantile agent is in possession of the goods. He has taken the consent of the pawnor. Then even if a pledge, he can also create a pledge as far as the goods are concerned and offer it as security with the consent of the pawnor. Then second one is a mercantile agent who is in possession of the documents of title. Documents of title is which confirms the ownership and title of the pawnor. When the mercantile agent, with the consent of the pawnor, is in possession of the goods and is in possession of the documents of title, with the consent of the pawnor, he can pledge the goods. Then then as far as the pawnee is concerned, or as far as the pledgee is concerned, he must act in good faith and he must act for the benefit of all. Here, pledge seller or buyer in possession of pledge by seller or buyer in possession of the goods after the sale. That is, suppose let us say pledge by seller or buyer in possession of the goods after the sale. The pledgee has to act in good faith and unaware of the sale of goods to the buyer. The limited owner pledger only to the extent of such limited interest pledged by co-owner when only to the extent of his with the consent of all. The question is the pledge is valid, and then possession under a voidable contract. Pledge is valid until the contract is void. First one is the pledgee or the pawnee has to act in good faith in case the property has already been sold by the seller to the buyer, and the pawnee is not available of the sale of goods. Then in that case, the pledge is still valid. Then when limited owner, suppose let us say you are only entitled for 1/4 share in the pledged goods, then you can only be made liable only to the extent of your share. Then third one is co-owners. That is, 2 or 3 people are owning the property. Then in that case, with the consent of all of them, the pledge can be created. Then possession and voidable contract, pledge is valid until the what do you mean by voidable contract, sir? When the vitiating elements of contract are present, when the contract is voidable at the option of the party who is a victim of the fraud or who is victim of the misrepresentation or who is a victim of any mistake, so on and so forth, or undue influence, then in that case, until that is possession under what? Suppose you as a pledger or you as a pledger, you as the pawnor is in possession of the goods. Then the question is until the contract under a voidable contract, which can be avoided, but till the contract becomes void, the pledge is perfectly valid and enforceable. So this is as far as law of pledge and law of pawn is concerned, contained in section 172 to 179. I've already told you that it's a species of the law of bailment. Then the last chapter, as far as the specific contracts, the biggest chapter is law of agency. That is sections 182 to 238. Here, here, please remember, sometimes I'll only give you an introduction to the law of agency, sir. Sometimes what happens is we cannot be omnipresent, we cannot be present at all places. Suppose Mr. Vasantrao belongs to Kamam and he has got some business interest at Hyderabad, then let us say he cannot come to Hyderabad often because he has got his interest based in Kamam. Then in that case, he appoints a person to look after the business, administer the business, do the transactions, deal with third parties, bring about a contract, honor the contract, make the payments, so on and so forth, and pay the taxes, pay the outstandings. All these matters are involved. So in that case, what happens is he appoints his nominee or constitutes an agency whereby he appoints an agent to look after, transact, and also carry on the business on his side. Or in other words, I can just give you a loose definition of the law of agency to say an agent is none else than a conduit pipe. Conduit pipe means connecting link between two pipes joined with a coupling, which brings about a contract between its principal and the third parties with whom the contract is entered into day to day. And then an agent is called in different forms. Sometimes a person is called an agent, sometimes a person is called a dealer, sometimes a person is called a stockist, so on and so forth, but all almost mean the same. So in other words, agent means a person who under an agreement with the principal acts for and on behalf of the principal, brings about a contractual relationship between the principal for whom he acts and also a third party. He acts as a conduit pipe or a connecting link between the principal and the third parties, and also he facilitates the running of the business, conduct of the business, day-to-day transactions, day-to-day collection of money, and day-to-day contracts, honoring the contracts, pay the outstandings, pay the taxes, pay the incidental expenditure for and on behalf of the principal. And normally it is done under the agreement called an agency agreement. Then, for all practical purposes, an agent is a person who sits and transacts business for and on behalf of the principal. He carries out the duties, he carries out the responsibilities that are assigned to him from time to time. And whatever he does, he keeps the principal in confidence, informs the principal about his day-to-day transactions, keep the account books, keep the sale register, keep the stock register, keep the various transactions with different parties, and also the outstandings which the principal has to receive from third parties. Then he is a connecting link who brings about a contract between the principal for whom he works and the third parties. Normally, earlier, there used to be a law of agency as far as banks were concerned. Previously, the branch managers who were there, they were designated as managing agents. That is, they sit and transact the business for and on behalf of the principal, that is the bank, and then they are responsible for all actions, and they are responsible for granting loans, they are responsible for making collections, they are responsible for honoring the outstandings, they are responsible for keeping accounts, and all transactions between the third party and the bank. And these bank managers could also file suits, institute legal action, criminal as well as civil, for and on behalf of the principal. Principal is the main bank, agent is the branch manager. Please remember, as far as just excuse me, please. As far as principal is concerned, he is the owner of the business. As far as an agent is concerned, he only comes into possession of the property belonging to the principal. And there is an agreement or a contract between the principal and the agent that the agent shall act for and on behalf of the principal. He shall bring about a contractual relationship between his principal and third parties. He acts as a conduit pipe or a connecting link between the principal and the third party. Fourth is he is responsible for the outstandings which are due and payable to the third parties for honoring a contract. He is also entitled to collect the outstandings from the customers who are due and payable the amounts, and also for all practical purposes he is a person who sits and transacts the business. But please remember, after the Companies Act was passed in 1956, the law of managing agency has now been abolished, and now even in the Companies Act they are all called managers and so on and so forth. As far as State Bank of India is concerned, which is a successor of the Imperial Bank, you do not have any agents. The officer concerned is authorized under the State Bank of India General Regulations 1955, or earlier we had the State Bank of Hyderabad and subsidiary banks. The State Bank of India Subsidiary Banks Act of Regulations of 1956, and all officers of the bank were authorized to sign, verify, and also institute suits for and on behalf of the bank. But as far as the other banks are concerned, you do not have any provision in the regulations which authorizes them to file suits, prosecute, defend actions. So every officer of the bank is authorized to represent the bank wherever he goes, and is given what is called a power of attorney. Power of attorney in Urdu it is called Mukhtar Nama. Power of attorney is nothing else than delegation of the powers of the bank to the officer concerned to do everything as an agent or as a representative of the bank to prosecute and defend actions for and on behalf of the bank, and also act as a conduit pipe between the principal and a third party, and also enter into contracts for and on behalf of the principal with the third parties, and also honor the contract for and on behalf of the principal with third parties, or is a connecting link between the principal and the third party. And normally, law of agency says it is normally reduced to writing. The agency is not given permanently. It is given for a specific duration of time, and the agent is either paid the salary or the commission for the services which he renders for and on behalf of the principal. Earlier, the promoters of a company, before the company comes into existence, act as agents, and they enter into preliminary contracts before the incorporation of the company, and then they bring about a contractual relationship between a third party and the company which is not yet born. And normally they act as the conduit pipe. They do the preliminary work. They prepare the memorandum. They prepare the articles. They prepare the prospectus. They call for shares. They submit the applications for and on behalf of the company with the ROC or the Registrar of Companies, and the company is born. And once the company is born, at the first general body meeting, the promoters are unanimously elected as the directors of the company, because all the preliminary contracts which they enter into for and on behalf of the company as an agent or representative of the company which has not yet come into existence, they have to be honored, so that a sense of confidence is created in the minds of the third parties who enter into a contract with such promoters. So, law of agency comes into operation everywhere. Suppose you take a petrol bunk. If you take the petrol bunk, we have got four major petrol companies. One is the HPCL, another is the BPCL, another is the Indian Oil Corporation, that is IOCL. Then we have got nowadays new companies have also come, SR, then Nayara, so on and so forth. These are all companies where they lease out, or where they create an agency or deal. They don't call it agency, they call it dealership. That is, these people, certain people are appointed as the dealers who sit and transact the business of the petrol company, and then whatever expense, whatever money is realized by sale of petrol, sale of oil, sale of gas, sale of so and so, or the petroleum products, they have to be properly accounted for and then sent to the principal or deposited into the account of the principal, and they get their commission for doing that necessary work. And nowadays we see, I see a lot of people, especially reputed shops like Karachi Bakery, Pulla Reddy, and other people. What they do is they are granting franchises to different people to sell their products. And if you see, please remember, Karachi Bakery is only one that is in Mosanjai Market, but you find a Karachi Bakery in ASR Nagar. You find one in RP Road, one in the airport, one in the bus station, so on and so forth. They're all franchises. They are all nothing but agents for and on behalf of the main Karachi bakery. The products which are sold by them, vended by them, is manufactured or produced by the Karachi bakery, and they pay the franchise money and get the right of operating the franchise. That is the Karachi bakery. Then different things are there. Then the question of Hindustan liver products also, they are granting franchises to different people. Hindustan liver does not manufacture anything, but they only market it. But for the purpose of marketing, they appoint agents and they appoint franchisees, and these people do the business for and on behalf of the principal. I think with this introduction, we would because law of agency, I've finished the law of pledge. But as far as law of agency is concerned, the agent is here. Please remember, all the principles of the law of contract applies as far as agency is concerned. What are those principles, sir? Section 11 of the Contract Act, which says both the principal as well as the agent must be of the age of majority. They must not be of unsound mind. They must not be idiots. They must not be disqualified by any law for the time being enforced to enter into a contract. Only in those conditions a valid contract can be made. So these incompetent people, as laid down in Section 11, are incompetent to enter into into a contract of agency. Then agent may not be competent. It has to be looked into with two angles. A person with whom certain acts is done is a principal. Please remember, no person can be omnipresent everywhere. Everyone has to believe someone or the other to transact his business, conduct his business, enter into preliminary contracts, enter into transactions, and honor the payments, honor the outstanding, honor the debts which are to be paid, and also collect the outstandings, and also order for the stocks from time to time, and also keep a sale register, stock register, and so on and so forth. And the principal cannot do all those things, but the agent acts for and on behalf of the principal within the scope of the authority that is given to him, either by an agency agreement. So, agency agreement is normally entered into between the parties, like partnership, etc., etc. What is the remuneration payable to the agent? What is the commission payable to the agent? What is the incentive that is given to the agent? What is the scope of his powers? Whether he is empowered to enter into contractual relationship for and on behalf of the principal, whether he has to pay the taxes and outstanding to the creditors, whether he has to collect the outstandings from various customers, whether he has to maintain proper registers, so on and so forth, and for how long the agency will remain in force, and what is the type of business for this man is appointed as agent, what are his rights, what are his duties, and what are his responsibilities. Everything will be embodied and incorporated in the agency agreement. It is an agreement between the principal and the agent. And once the period comes to an end, the agent has nothing to do. He has to vacate and hand over possession. You are seeing many petrol bunks where, suppose, let us say, an agent takes it from the main company and it is given for 5 years. Once the 5 years comes to an end, the agent has to surrender possession to the principal company and he cannot act as agent anymore. I think with this introduction to the law of agency, we shall have a break today and then continue with the rest of it, because this is the biggest chapter as far as the Contracts Act is concerned. It has to be gone into very minutely and very carefully. Are you able to follow, please? Any questions by way of interaction? Any questions, please? దీంట్లో వచ్చిందమ్మా చదువు. Any questions, please? I'll wait for 5 minutes. Try to formulate your questions so that you can get it clear. Yes, Mr. Vasantarao. Yes.
Sir, good evening. Sir.
Good evening, Nokia. Jamuna Tiwari.
Yes, sir.
Yes, madam.
Sir, అది deficiency of amount ఉంటే అది డెవలప్మెంట్ లో మనం మూవేబుల్ ప్రాపర్టీ ప్లేస్ పెడతాం కదా, అయితే అది అమ్మడానికి ఉంటుందా రైట్స్?
See, whatever it is, suppose a notice is given to you asking you for payment regarding the loan which you are due and payable to the pawnee. Then let us say you do not pay. Then a suit is filed. Then the question, the question is the pawned goods or the pledged goods will be brought to sale. And if any deficiency is there and the loan is not satisfied, then the pawnee can proceed against the other property of the pawnor and recover his money. Are you able to follow, please? Any shortfall is there, the pawnee has got a right of proceeding against the other properties of the pawnor and then recover his money as far as the deficiency is concerned. Is it clear to you, please?
Yes, sir. Yes, sir. Thank you, sir.
Welcome. And tomorrow it will be only interaction.
Tomorrow is an interaction session. If anyone have interest, please come and join and ask your questions.
And no questions on chat box.
Yeah. No questions on chat box. So we are winding up for today. Good night all.
దీనికన్నా స్పూన్ ఫీడింగ్ ఉంటుంది. ఏ హాలిడే మూడ్ అన్నించి ఏం చేశాము? ఇదిగో